on Chapter 9. This week we're dealing with both Chapter 19 and Chapter 14. Chapter 9 concerns the court system, and Chapter 14 is about, as the book puts it, crime and punishment. It has nothing to do with Dostoevsky, really. It is about, punishment. I'm grouping them together for kind of obvious reasons. In this lecture, we're just talking about Chapter 9, the courts. When we talk about the court system in state and local government, we can make certain generalities, like so much in this course. I have to say right at the outset, it depends. And you might think about the court system as being somehow immutable. It's not. That's why I can't even say, well, Missouri right now has such and such a court system, because these systems are described in this state constitution. And as you remember from earlier chapters when we were talking about state constitutions, it is much easier to amend state constitutions, change those constitutions, than it is to amend the U.S. Constitution. So the U.S. Constitution has 27 amendments, and the whole process of changing the Constitution is quite difficult. That's not true for states. You can have changes in the way in the Constitution, and hence also changes in the way the court systems operate. And this happens on a relatively frequent basis, that states reassess, for example, a 3 strikes you're out setup, or a truth in sentencing provision, and fine-tuning things on a regular basis. So I'm leery of making blanket pronouncements in this area. There are some basics we need to understand that are true. I don't expect to be changing this delineation between civil cases and criminal cases. Even there's some, unfortunately, some gray areas at the state levels. Local courts in recent years have come under fire, as some jurisdictions have attempted to imprison people for essentially not paying fines, which would be, it's something that a relatively new approach to fundraising for localities. But this is something that different jurisdictions, for example, in Ferguson, Missouri, this has occurred in some places in the South, Texas. In general, we have this delineation, though, between civil cases and criminal cases. There's a lot of ways you might think of this. So in general, one's liberty is not at risk in a civil case. Another way to think about it is, in a criminal case, the government is the plaintiff. In other words, it's a crime against society in one way or another. A murder, a robbery. Civil case, you malign and insult your neighbor, and the neighbor takes you to court for slander or libel. That's a matter between you two, right? That is an example of a civil case. So fraud would be, when there's a fraud cases, when the court is charging someone with criminal fraud. That is a criminal case. The government is a plaintiff. If you are suing your neighbor because he sold you a lousy automobile, and you're seeking a civil judgment, that's a civil case. If it if enough evidence is shown that your neighbor routinely um, sells fraudulent goods, then perhaps that could become a criminal case if it goes through the process of having evidence produced and shown to a grand jury. But if it's just between you and your neighbor, that's a civil case. So, um, in general, they're they're delineated pretty clearly. Also, when we talk about generalities, basic structures of state courts, remember this is parallel to the federal system. You have trial courts, appellate courts, and state supreme courts. I'm not going to go into a lot of detail because, for example, the state supreme courts, it can be pretty complicated. Uh, it varies, and also with the appellate court. So sometimes um, there can be sort of the flow chart might actually not be limited to just three little boxes, but actually, 4 or 5 sort of parallel jurisdiction. But in general, we have these 3 levels. The trial courts are where the action happens. They are the sometimes called the court of first instance. The appellate courts are the courts that deal with the problems, if there's a problem in um, the way that the trial was conducted. It's not the chance for the defendant to get a do-over. But if, for example, your public defender showed up drunk at the trial, you might appeal that decision because you were not given adequate representation. And finally, of course, you have the state Supreme Court as ruling on issues of state law, and also if there is an appeal of an appellate court decision would go to a state Supreme Court. So you have at the trial court level, as I mentioned there, the court of first instance. You have the bench trials occurring there. This is when the judge is just hearing the evidence. This is often how it happens. If it's a criminal case, then you have the right to have a jury. Also, since we're talking at the local level, you have the contrast between general jurisdiction versus limited jurisdiction. Even in a town like Hagerstown, the judges, which is a fairly large, mid-sized city, let's just say, the judges there will be hearing cases in a general jurisdiction basis, not just criminal. So, same person that hears a murder case will also be might be hearing a divorce hearing, something like that. So that's sort of the distinction. The appellate courts, as I mentioned, they are looking at cases where there's been some sort of what's called prejudicial error, some flaw in the way that the trial was conducted that weighted the decision one way or another unfairly. You have in different states, you have this contrast between discretionary or mandatory jurisdiction. This has to do with their ability to choose what they're going to, what cases they're going to have. So, if there is discretionary jurisdiction, then the court can decide whether or not to grant review of a case. If it is mandatory jurisdiction, it means that every case that comes up, they have to hear. En banc versus panels is basically how those cases are being heard. En banc means they're being heard all together. That is, all the judges of the appellate court. Sitting en banc literally means on the bench, right? Versus panels might be smaller groups that are hearing it. And the state Supreme Courts, as I mentioned, are the have to do with interpreting the state's constitution and also hearing anything that case that is coming up from the appellate courts. There is a perhaps unavoidable problem as we wrestle with the idea of who should be a judge. How do we choose judges? We have the question of, well, should they be appointed? Should they be elected? There are people who say, well, judges are obviously play a large role in people's lives, a large number of people, if we're unfortunate enough to end up in court. Where's the accountability? On the other hand, how do we preserve judicial independence? So there is this potential conflict or a balancing act that needs to be managed somehow. I don't think anyone would say that it's balanced perfectly. And in some ways, you could make an argument that the situation has gotten worse in recent years. We'll talk more about that a little later. If they are elected, then you have the option of, in some states they're partisan elections, some states are nonpartisan. Even when they're nonpartisan, there's a question of, well, how nonpartisan are they? Because the nominees are frequently selected at a convention or in some other partisan manner. So, the argument, as I mentioned, is that this provides at least a veneer of accountability, right? But there is a question: should the judges be making decisions that are popular, that are necessarily popular, or should they be making decisions that are just and correct and legally correct and even fearless? If you think about some of the notable court decisions that have been made, I think there's a preponderance of opinion still that Brown versus Board of Education in 1954 was a groundbreaking decision that paved the way for desegregating U.S. society, right? Desegregating U.S. schools, first of all, and then leading to all sorts of ramifications. But that was not a popular decision. That was not a decision that was made to be popular. In fact, it was quite controversial, and to some extent, it still is criticized by some people on the far right. But that's an example. There are many others where court decisions are not necessarily popular. So is that really what we want? Is that really what society needs? This is a sort of a philosophical question. On the other hand, there is the idea of appointments, having pure appointive systems. And there's even systems such as the Missouri Plan that tries to strike a balance between the two, between having appointments and then having confirmation elections. And Maryland has a system that is similar to this. As your book mentions, these were implemented, and there was a lot of interest in the Missouri Plan. They're a little bit less popular than they were a few years ago. So this is the idea is that there's a balance that needs to be found, and because it's a balance, there's two conflicting approaches, and no one is going to be happy. Excuse me, not everyone is going to be happy no matter what you do. That's basically the bottom line, right? Um, Term limits and terms of office. Again, this is one of those. It depends. It depends where you are. It varies widely. In Maryland, we have a mandatory retirement age of 70. Also have this in Massachusetts, New Hampshire, Rhode Island. You get a life term. It really depends about. So this is there again. There are arguments on both sides of this. Compensation varies widely too. There's a nice little table in your book that shows. Hey, this kind of makes sense if you think about the you have Maine, for example, which is a relatively small state, being there at the bottom, Maine and New Mexico, and at the top, California and Washington D.C. So it kind of makes sense as far as standard of living, etc. But it varies widely. It's on page 298. Who are the cast of characters in this legal system? The prosecutors are the people that basically the government's agent to get justice, to present the case of the government. The defense attorneys are the lawyer hired by the people who are accused of something. Public defenders are the lawyers who are hired in order to provide some representation to people who can't afford it otherwise. And this is, again, one of those situations where it depends, because in some states you have a public defender system that is overworked, overburdened to the point of being non-functional. Louisiana is a good case of this. I'll probably post a link to some of the horror stories that have been uncovered in the situation. If you think about it, remember they're public defenders, so who's paying for that? That's the public. And the public likes to pay for things that are popular. Public, they don't like to. They'll pay for a road because they recognize that a road is necessary. They'll pay for a sewer system. But how do you feel about defending somebody who's been picked up because he has raped, a 9-year-old girl, and he's broke, right? How do you feel about that? You probably don't feel too happy about that, right? But the fact is, he's accused of something. He can't afford to pay a lawyer, so that representation is paid for by whom? By taxpayers. And this is one reason why this office is frequently one of the most underfunded offices there is, and why it varies so widely, right? Because in some states you have a greater adherence to this principle of innocent until proven guilty, and there are some states where the rights of the accused are not recognized as significantly. So if you look at the amount of budget allocation for these offices, it varies widely across the United States. If you're going to be a poor defendant, you're much better off being a poor defendant, for example, in Massachusetts than you are in New Orleans or Texas, because in Louisiana the system is it broke down entirely, and people were sitting in jail for a year, more than a year, without trial. So, juries, of course, if you have the right to a jury if you are accused of a criminal offense, but oftentimes the whole criminal justice system operates on plea bargaining. So, as much as possible, the prosecutors will be trying to streamline the process to eliminate even the need for a jury. In order for the prosecution to move forward, they need to get an indictment. The indictment is voted on by the grand jury. The grand jury is presented evidence. It can be, usually a prosecutor or assistant prosecutor, district attorney, assistant district attorney is there with a policeman or a detective who will recount how such and such a person was investigated and arrested and what the evidence is. And if you sit through this process, as I did about a year ago for about 6 months, it can be very repetitive and sort of you might wonder, like, why are we going through all this when the person has essentially confessed? Well, the point is to build a check on the power of the prosecution, that the prosecution cannot move forward with an indictment unless there is lots of strong evidence to bring someone to trial. And this is a critical point, that indictments are not to be handed out lightly. They're only handed out when there's strong evidence to support it. The defense attorneys, as I mentioned, are charged with defending the person accused of the crime. You do need to know about the Supreme Court case of Gideon v. Wainwright. This is the case Supreme Court case that basically provides, or I want to say guarantees, the provision of a public defender when a defendant can't pay for it. Gideon was a small, low-level, had been accused of low-level crimes, was arrested for breaking and entering, burglary, whatever, in Florida. And because the state of Florida interpreted the law as saying that he didn't need an attorney because he wasn't charged with a capital crime, he wasn't provided an attorney. The Supreme Court reversed that decision by the Florida Supreme Court, and as a consequence, not only are people now provided with public defenders, but quite a few previous convictions were overturned because of that decision. So, juries, we have, I guess it's important to distinguish between the petite jury, which is the jury that actually hears the evidence provided during the trial, and the grand jury that votes on bringing an indictment. Very, very clear difference, right? Jury selection is generally done with a random group of people who are registered voters. It is a process, so it can be quite a long process of choosing the juries. Ideally, people who are not do not have this pre-bias that will prejudice them uh, for or against a defendant. In the trial, it's basically that um, they're basically judging the facts, right? The facts that are presented to them. As your book puts it, they are the fact finder, right? At that point. So when we talk about balancing acts, we have the balancing act between the defendant's rights and the victim's rights. When you talk about defendant's rights, well, so this would be Gideon v. Wainwright. Okay, this is the Bill of Rights. That is the first 10 amendments talks about defendant's rights pretty explicitly, guarantees them. The victim's rights are more recent development, beginning about the 70s, beginning attention to people who felt that judges were too lenient, that criminals were getting set free too easily, etc., etc. And in these debates, you kind of see reflection of general societal problems, right? Rise of crime rates in the 70s, racial friction, manifestations of prejudice. We see all sorts of different currents manifested in this conflict. As a response to the victims' rights movement, we have the introduction of provisions like mandatory minimum sentencing laws. This falls under the sentencing guidelines. And you have habitual offender laws, truth in sentencing laws, basically saying, that somebody who is sentenced to this or that amount of time actually has to be serving that amount of time. And again, with these, on one hand, we have a desire by some people to have a stricter sentencing guidelines, the 3 strikes, you're out. On the other hand, there are consequences of that. You have, if you have minimum sentences, sometimes that can lead to some unanticipated bargaining at the trial level, because if you know that you are going to be facing a term of, say, 30 years, well, you're going to be reacting to that. If you were a defendant, you're going to be reacting to that far differently than if it's a term of 5 years or something, right? You're going to be appealing as much as possible. So sometimes these minimum sentencing guidelines can actually lead to more plea bargaining and people, bargaining down the charge so that the actual term served is not that great. The caseloads in general have been increasing dramatically. This is at not just the state and local courts, but at the federal level, right? And so this means more plea bargaining at the federal level. It's you're guaranteed a right to a jury trial, but the number of cases that actually fall into that provision or where that occurs is a very small minority. Some people have estimated it's less than 5%. So you see an increasing amount of attention to figure out ways to streamline the process and still provide justice. The terms like the rocket docket, really specializing in certain types of cases to get them out of the general stream of cases and deal with them differently. You have at least two subjects of court reform that was talked about: how we are choosing judges. So this is a perennial way. Do we elect? Do we nominate? How are we moving ahead with that process? And also making sure that people are being sentenced fairly and uniformly. This is a continual problem. When we talk about the selection and the election of judges, we also have a growing problem really every year since the Supreme Court decision of Citizens United, which not only lifted limits on campaign spending for state and national elections that we think of, president, whatever, governor, but also judicial elections. So these, as more money has become available for these electoral fights to be fought, more money has been spent, and as more money is spent, there are increasing questions about the judicial independence. Is it really realistic to think that a judge is going to even-handedly decide on a case when one side of the case has donated, say, $100,000 to his election campaign? Is that really realistic? Can the judge really put aside what he knows about how this person has helped his individual effort to get in that job? Are we really being realistic? Or are we fooling ourselves? This is a question, because this is something we are seeing increasingly as the effects of Citizens United are rippling through our electoral system. So I think it's important to recognize, this is something we talk about at Politics 101 as well, that when we're talking about the judicial system, it's not like the judicial system is somehow removed from the political process. It's not. The same politics or political consideration and questions of political philosophy that motivate elections for governor also, to some extent, are involved in the judicial systems. And finally, as I say for basically almost every chapter here, that how the judicial systems operate in the individual states varies widely. So what happens in California is quite different from what happens in, Illinois. So on that note, I hear the sirens approaching.